Breakfast. Now, the country's apex court has fixed October the 22nd as a hearing date for a lawsuit filed by 16 state governments challenging the legitimacy of the Economic and Financial Crimes Commission. The lawsuit, initially filed by Kogi State, questions the constitutionality of the laws establishing the EFCC. The 15 other states that joined in the suit are Ondo, Edo, Oyo, Ogun, Nassarawa, and Kebbi states. Others are Katsina, Sokoto, Jigawa, Enugu, Benue, Anambra, Plateau, Cross River, and Niger. A 7-member panel of justices led by Justice Uwani Abba-Aji scheduled the hearing after granting the state's request to join as co-plaintiffs and consolidate the case. The counsel representing the states made their submissions in court, with most seeking to be joined as co-plaintiffs and 2 states requesting case consolidation. This lawsuit has significant implications for Nigeria's anti-corruption efforts, and the outcome will be closely watched. Let's talk this through by speaking with a lawyer and social development advocate, Olutobosun Oshifora. He's joining us in the studio. Thank you so much for joining us.
Good morning. Always a pleasure to be here.
It's a beautiful thing that we have you to discuss this matter, because it's actually something that is very germane and something of interest to you. But if you look at what the Kogi State government who initiated this suit, challenging the powers of the EFCC and FIU over the administration of state funds, arguing that these federal agencies overstep the boundaries, I know. But what legal implications or basis for this challenge do they have for this challenge, and why has it gained the support of 15 other states?
All right. What we want to look at today has both legal and moral implications.
That's right.
And I think it's best we just put it open. Though I'm not here to moralize, I'm not a clergy, I'm a lawyer. All right, I'll speak more for the law, but also I think we should look at the moral implication of what's going on. But let's start with the law. Now, basically, what has happened here is very simple. You know what's going on in Kogi. The immediate past governor has been haunted for, well, let me not say haunted.
Hounded.
Not hounded. Maybe he has been invited, and there's been so much drama to, his coming and not coming and everything. It's been quite evasive and dramatic about it. We all see it. We all saw it. We see it. We see what's going on, and we know what's going on.
Now, but Jerry and
yes.
Tom and Jerry.
Now, but basically, what has happened here is, I think part of their effort to escape is now going to look at the Establishment Act of the EFCC, and we will break it down. That's why we're here. All right. Now, let's look at how EFCC was formed and their own argument. In fact, the argument stemmed from a recent case in the Supreme Court, OBK versus Federal Republic of Nigeria. Basically, what happened in that case was it was a case that started from the High Court all the way. It involved a senior advocate of Nigeria. All right. No, so what happened in that case was they were challenging the fact that EFCC, there were certain charges against the Learned Silk. So, and in the course of the trial and everything, a few things came up, which now bordered on the powers of the EFCC. Now, so the Supreme Court literally said that Section 1, which established the EFCC, should be read in conjunction with Section 6 and 7, which shows the functions and the duties of the EFCC. Now, so, and that they went, it was a lengthy decision. They outlined all the works of the EFCC, which primarily includes investigation, prosecution of offenders. Now, they went on to explain the powers of the EFCC to the extent that even where, in law, if the act or if the law doesn't provide for a crime, you can't prosecute someone on it. Now, so they went on to say, based on the law establishing the EFCC, that the EFCC has powers to even oversee, even where the act doesn't provide for certain offenses, that as long as the offense is related to economic and financial crime and it's in other laws, the EFCC has that overreaching powers. It's there in the law, it's there in the Establishment Act of the EFCC. So the Supreme Court explained everything. So something came up. It was Section 46 of the EFCC Act that talked about a particular, the powers of the EFCC as it is. Now, so the Supreme Court had to explain that, see, some of these things should be read in context, that you cannot give EFCC open-ended powers in respect of criminal offenses. That was what happened. So the justices of the Supreme Court now went to explain how the EFCC came into being, that it was with recourse to a convention of the United Nations in 2003. That's right. There was Convention 58/4 of 2003. I think it was something around 31st of October 2003, where the United Nations, the convention was primarily against corrupt practices. Now, but they narrowed it down to the fact that instances where public officers steal funds or pilfer or take money and then take the funds abroad and establish themselves or whatever they want to do, that now creates a situation where succeeding governments are now stifled fund-wise, that states should come together, collaborate, that where you find such funds, send it back to the present government. So that was the essence of that convention. So the fallout of it was that states should come together and domesticate this thing in their laws. Basically, corruption against public office and bribery. That was what happened in that 2003. The fallout of it was the EFCC Act of 2004, Establishment Act, which established the EFCC. Now, the argument of Kogi and the 15 other states that have joined them is this. Section 12 of the Constitution says, it talks about treaties, conventions, and domestication of foreign laws. It says that no treaty shall have the force of law, except it is domesticated. He now went on to say that the National Assembly shall have powers to make laws for the country, outside what is in the exclusive list. Yes. So 12.3 now says that the majority of the House of Assembly are the ones that will vote in respect of such treaties, such conventions, such laws, for it to be fully domesticated into our laws. Now, so what they have done here is to challenge that. They are alluding that there was nothing like majority ratification of that convention that bettered EFCC.
So I think this also means that there may be a political undertone to this. You mentioned the moral, you mentioned the other one. Well, you have not talked really about, the moral aspects. But of course, we can see the political undertone that we're talking about. And it's important to note that even in July, the Kogi State House of Assembly actually passed a bill for the creation of their own state anti-graft agency. How is that likely to work for an investigation? And I'm bothered about, if the EFCC is not to perform this duty, what other agency do we have to actually, perform this? There are
a lot of agencies that the EFCC has just been made the coordinating agency on Nigerian financial intelligence.
Crimes?
Financial intelligence, basically. Now, so every related crime, they have the powers to actually go into it. In fact, the EFCC Establishment Act even listed other acts with which the EFCC has powers to delve into. Now, but coming back to this, before we even go to the morality of the case, the fact is that try and look at what they have brought before the court. They said that the EFCC should be stopped or prohibited from investigating and prosecuting public officials that have put hands in the till. That, for me, is a sad development. Everybody has a right to go to the court. That's right. The court has the ultimate right to pronounce on what is good and what is bad.
Where morality comes in.
That's where morality comes in. Now, but before we even go play the moral card now, basically what this is saying, it's not particularly tidy for the nation. We know the country has a funny image outside. that Nigeria is corrupt. Nigerians are corrupt.
In fact, fantastically corrupt.
Now you have now brought this case to say that, okay, so if the court stop any form of investigation and prosecution of people who steal public funds, so what's going to happen? At the end of the day, there won't be funds to steal again. That's even one part. But then, so what happens? What message are you sending down to the youth, to the populace, to the hungry person on the street?
But that's why they are suggesting their own state-owned anti-graft agencies. Are you saying that's not going to work?
So, you want to establish your own state anti-graft agency. To do what? To replicate the work of an established agency that is already vested with powers constitutionally and otherwise to do this. What are you trying to do?
And that will bring to the fore.
Well, in their defense, they are trying to localize the agency.
To what extent? The same suit is saying that don't stop us from even... I saw Comrade Adewale talk about the independence of the local government. You know what is happening between states and local government. It's a fight that I think before Christ comes, it might end, it might not end. But the fact is that state governors are so comfortable putting hands in the coffers of the local government's funds, and they do it brazenly. And in fact, I mean, you saw there was another suit in that regard where they were actually against the autonomy. There's nothing. The fact is that they just want to take the money. And then you're trying to do the big brother thing, and then you take the whole funds. These people are supposed to... So it's part of the suit that don't prosecute, just leave us. They can't leave you.
Even if they are trying to domesticate it, we see what they are doing with the state electoral commission.
Exactly. Exactly. I was going to go there. That see, the same people who you saw what happened over the weekend. You saw how governors, entrenched their own persons based on the state electoral commissions, and you saw how the elections went. So you want your own state anti-graft agency that you will use to face other people and not yourself.
Well, we are actually advocating what's it called? Governors to be original chief security officers of their state to ensure that they fight insecurity to a standstill. Now we see what is happening regarding corruption, but we just quickly have to raise on to a break.
Golden penny spread, easy to spread and good for the family.
Thanks for staying with us here on TVC Breakfast. We'll be talking about the country's apex court, which fixes October the 22nd as the hearing date for a lawsuit filed by 16 state governments who are challenging the legitimacy of the Economic and Financial Crimes Commission. And we've been speaking with a lawyer and social development advocate, Olutubosun Oshifora, who has been making us understand, the legalese and also the morality and then the political angles to these current developments that we're having from different states, or that we're having some things behind the scene, some of which we do not even want to talk about. But if you look at our drive to fighting corruption in this country, vis-a-vis stemming the tide of rising insecurity, food crises and every other thing, and then the last conversation we had with our last guest, he said something about removing the immunity from the state governors and some of those who have immunity, and let's see what's going to happen so that we'll be able to monitor them back to back. Speak to the morality of this issue, for us to understand, and what Nigerians should understand and do about this situation, even though it's before the apex court.
All right. Basically, no. I understand. Yeah. I mean, we can only discuss. I mean, there's nothing stopping us from discussing the matter. All right. We cannot just say this is what the outcome will be or something. So there's no law prohibiting us until, I think it was the Senate president that was suggesting something like that some days back, that people should not be allowed to discuss matters that are in court.
No, I think the new CJN also, made some similar statements.
Yes. So, but basically, coming back to this, I think what happens in this case, I'm being careful about the morality of the case, because it's a sad event, really, and the optics are particularly bad. because
especially when you look at Nigeria's image
outside, even within, you know, even the average person it's an us and them kind of thing that you just feel, okay, those in power are the ones taking everything, and we that are on this side is literally a case of nothing for us. Now, but you see, I mean, looking at this case as it stands, optics, particularly for me, are not, morally speaking, are not fantastic, because it's as if some people wake up to fight corruption, and some people, on the other hand, wake up that this corruption must stay. That's it. Because if you're trying to, I see a lot of cases where people come to court, and particularly public officers, you know, they get lawyers to file things like stopping them, perpetual injunction from being investigated and all that. Coming back to what Comrade said about immunity, the essence of immunity is not to shield you from being prosecuted or investigated for corrupt practices. What happens? Why you have immunity for governors, deputies, and the president and the vice president? It's literally not to be distracted. I can tell you there are cases that would distract you 100%. And you can imagine the plethora of cases that will come. So that's the essence of immunity.
Someone who does not
have
any intention to deliver good governance would use it as an alibi.
Use it as a shield. Exactly. So they will tell you that because I was going to court that's the essence. It's not a shield for corruption. But somehow Nigerians have a way of metamorphosing into something else. You know, that's basically what it is. You know, something simple. We just create our own version as it suits us to protect us, you know. So that's basically why. So people advocating for removal of immunity, they know why they're saying it. Even after we've seen instances where after leaving office, public officers, governors, former this, former that, you see them, they try to use the instrumentality of the law to shield them. You've served as a public person. Why are you saying you shouldn't be investigated? Come and give account of your stewardship. What is hard in that? It's not a big deal.
Okay,
but they use everything to protect themselves. So these are the reasons why cases like this don't speak well for the fight against corruption.
That's right.
Well, so in recent times, I mean, we cannot really say we want to take out. We cannot really, take out the EFCC out of some political and even non-political issues. I'm sure your mind may be going back to a particular case that has been going on social media involving the EFCC. Now, let's talk about who checks the EFCC themselves. I mean, we're fighting corruption. Can we say the agency is totally not corrupt in that sense?
All right. Now, so when you talk about checks and balances, most laws that establishes agencies always create checks there. All right. Now, because you find that the approval of certain offices, for example, are subject to certain checks. Even removal of that person from the office, like the chair, is subject to also some other forms of checks. Now, so that's basically what it is. It's not as if the EFCC exists absolutely without checks. In fact, one of the things that you find in the Nwobike versus Federal Republic of Nigeria case was where the Supreme Court actually had to put it to our face and streamline the powers, and the Supreme Court said that these powers are not, that section 46 is not absolute. You see, so things like interpretation of the law, which the court does, it's a form of check. Because it now narrows down what you do. So if you're looking for check the way you understand check, it may not work like you want it to be. But there are checks and balances for agencies like this. Because if, for example, the chair appoints himself, he has absolute powers, then that's where you say there are no checks.
Well, so in recent times, I will say that we've seen a bit of involvement in a bit of politics. I'm trying to take them out.
Okay.
How they can be independent in that sense.
I understand your position. So what happens is that when somebody is being prosecuted, he plays the card that is available to him. I served in a public office, for example, and then I'm done with my tenure. I've been called in to account for my stewardship. the simplest card I can play is the opposition. I'll just point at the opposition, or I'll point at some traducers or people that I feel that are on my case. But the fact is that, excuse me, sir, what they have asked you to do, have you done it? You can read any meaning to it, but the primary thing, I try not to take my eyes off the ball. Just keep, somebody has been called in that, okay, come and account. You're running helter-skelter, you're doing this, getting injunction, doing everything, doing press releases. And
that's right.
The primary thing, because it's easy to be lost in the argument that it's political. Some of them, well, we can actually adduce the fact that, this is a political move, this person did, we've seen all things from, I mean, if we speak from 1999 to date, we can say we've seen presidents, literally use some of these agencies to go after some persons. But the primary thing is this: there were some other persons they didn't go after because they are clean. Yes. So even if the move, so what I'm trying to sell to you is that even if the move is political, they have found you culpable in certain extent. Now, so it may be political, but the undertones, what underscores it is the fact that you are still answerable to the people.
That's right.
You're answerable to the law and the people.
So
what they do is, even if it's political, let's try and shy away 1 second from the political angle. The fact is that, are you or are you not supposed to account?
That's right. That's right.
Then, even if it's political, you go there, stop running. Go and explain yourself. If you know you're clean, I mean, the Holy Book says, the Holy Book says that the prince of this world came and found nothing in me. You to go. The agencies have come. And if they found nothing in you, they allow you to go.
And it's how we have other states also joining in this.
They will join because they are birds. I mean, they say birds of a feather flock together. So, I mean, if I see that what you're doing, what she's doing, is going to protect my interests, the enemy of my enemy is my friend.
Very quickly, I want you to quickly speak to this. A central argument to that is that EFCC and NFIU lack the authority to manage and investigate the administration of state funds. From that legal standpoint, which against that backdrop, where does the line between federal oversight and state autonomy lie, particularly when it comes to financial matters? Very quickly, because we are actually out of time. And is this primarily a legal battle? Or she had already talked about the political battle, or does it reflect the deeper tensions between the states and the federal government? Very quickly.
There is no tension. There's whether deep or shallow. There are no tensions. The fact is this: she's talked about accountability and checks and balances. In as much as autonomy is supposed to give you free hand to operate politically, there is no free hand against stewardship. I mean, sorry, let me put that well. There's no free hand against accountability.
Okay.
You are accountable. That's where these things come in. So somebody challenging the EFCC, NFIU, that they can't do this, somebody has to account. You see, one of the things we need to drive into people's skull is the fact that you don't go into public offices and you're brazen about everything. You just go, you don't want to be challenged. Your authority is not absolute. It might be absolute on paper, but accountability speaks against the absolute powers. Because, like they say, power corrupts. Absolute power corrupts absolutely. So that's the way it works. So accountability must be stressed.
That's right.
That's it.
And that's the point, accountability. And we people must also demand for accountability from those that are holding elected positions. Thank you very kindly, lawyer and social development advocate Olutobo Sonshipora. Really appreciate you for your keenness of insight on this crucial matter. 12 days, we are just 12 days shy of October the 22nd, where the Apex Court will be making the final declaration on this matter. Thank you, sir.
We will come back.
Thank you. This